And so when we're looking at what the US Department of Education did here, the short version is that they're essentially looking at the ways in which sex discrimination, so this presumption that based upon someone's sex assigned at birth, that you can make certain presumptions about that person's gender or about who that person might be attracted to or might not be attracted to, so their sexuality. And so essentially what the Department of Education has done here is they're using all of that stuff that was happening like years ago in workplace law to have a more comprehensive understanding of sex discrimination, which again is like 100% what Title IX is about. And so what this means in 2014 is that the Office for Civil Rights, essentially the Department of Education, had a really clear guidance that said, if you are a trans student who is dealing with discrimination based on your gender identity or this failure to conform to these stereotypical notions of gender expression, that might be sex discrimination. Because if someone is discriminating against you based on what they perceive to be your sex assigned at birth, that is automatically sex discrimination. There's lots of case precedent in the workplace that really sort of clearly address that question. And the US Department of Education, the short version is they're really relying on that for this particular statement they've issued. So fast forward 2 years, and 2 years later, the Department of Education went a much bigger step forward, and they issued a formal Dear Colleague letter. So the Dear Colleague letter is probably something most of us are familiar with in this particular context. But essentially, what the Dear Colleague letter is a more formalized guidance. So in 2014, they were saying, hey, if you were someone who has experienced this, it might be investigated. We are going to accept the complaint. Please send us the complaint. We might investigate if it rises to a Title IX violation. And in 2016, the big difference there is it was very clear guidance that was sent to schools across the country. So sent out to public schools, K-12 educational settings all across the country, sent out to colleges and universities all across the country, and obviously made really big news. So the average person is seeing it likely for the first time. But it also had very specific things that we'll talk about here in just a moment. But that 2016 Dear Colleague letter very much built upon the 2014 statement that the Office for Civil Rights at the US Department of Education issued. And that is very much built upon all of the stuff that was happening for like 20 years prior in terms of workplace law. So quick note in terms of how does this law apply to the community? So again, the idea with sex discrimination, and this is essentially the same way it's argued in that Supreme Court case regarding the workplace this past summer, is if someone is making a presumption about your sex assigned at birth and using that in some discriminatory fashion. So if someone looks at me and makes a presumption about my sex assigned at birth and says, well, I know that your sex assigned at birth was male, and I'm not going to use they, them pronouns for you because I want to use he, him for you. That might, depending on a couple of other factors, potentially rise to an issue of a Title IX violation. And so essentially, this law applies to the community because when you're using someone's sex assigned at birth to make this presumption and to engage in any type of discriminatory act related to gender identity or gender expression or sexuality, all of this case law and the recent stuff from the Supreme Court essentially has said, well, you've made that presumption, and at the core of it, you're making that presumption based upon someone's perceived sex assigned at birth. And so that's automatically sex discrimination.